So friends, let us now get into understanding the various essentials that make an agreement a contract. Now, the first essential ingredient for an agreement to be treated as a contract and to be enforceable as a contract is that there must be an offer. The term offer is used in common law and in UK contract law, whereas if you refer to the same word being used in the Indian Contract Act 1872, it is the term proposal. To be honest, offer and proposal are nothing but some kind of an initiation of commercial relationship. Of course, we know that for any contract or a commercial relationship, you need two parties, right? So one party probably makes an offer, the other party makes an acceptance. So suppose it may be the seller who says, I am willing to sell my house to you. And the buyer then says, I am willing to accept your offer. So offer and acceptance actually creates this kind of a contract, right? So, you can probably also relate it to getting an offer letter in employment. Maybe the company that is going to offer you a job may give you the offer letter. And in case you decide to accept, you also give an acceptance letter or a joining letter. So offer is the foundation of the start of the contractual relationship. And the offer can be made by anyone. The buyer can say, are you willing to sell your house to me? That can also be an offer. So in that terms as well. So offer starts the contractual relationship. And interestingly, you will notice there are certain ingredients of what this offer should be. You will notice that sometimes offer is expressed. And please note, when we say expressed offer, it can be expressed either in words spoken or in words written. I told you previously that contracts were, generally, in the initial days, if you look at the number of cases that were decided in common law, most of them were oral contracts. So even if orally you express, it is an express contract, right? Because you can understand what that offer is. But interestingly, we also say that offers can be implied. Now, implication or implied contracts are based on, something that is by contract. Right? Now, suppose I come and keep my phone at your table and say, use it, let's see. So, by conduct, things can also come into place. Now, for example, an auto that is standing in an auto stand, it's an implied offer. It's an implied offer that he's willing to ferry you from destination A to destination B if you are willing to pay the fare. Right? So it's implied in that nature. The bus that comes to a bus stand, it's an implied kind of an offer. You can come, hop in, there is a destination that is written, it will probably take you to the destination if you are willing to pay the price for the same. So these are generally the kind of nature of offers that can actually be made. So there are different methods of making this offer or proposal. Certain offers can be very specific offers, because please note, when we say specific offer, we generally say it is an offer that is made from one individual to another, and no other individual can actually pick up that offer. So it's between two parties. So I say that this offer is only open to Mr. B and no one else, right? So I am very keen who I want the offer to be accepted to. And in specific offer, generally, most of the things are very clearly stated in terms of the subject matter of sale, when the contract is to be made, and also you will notice that in specific offer you say, if you don't accept before 5 p.m. today, the offer expires. Right? So everything is clear in a specific offer. It is not an open-ended offer. Things are very, very clear. So in most modern day commercial transaction, I think the offers are very, very specific. For example, in employment, they very clearly say, if you don't join before 1st of April, this offer is terminated. Right? It's very specific in that context. Then finally, you talk about general offer. Now, please note the distinction between, say, a specific offer and general offer is, in general offer, the offer is made to the world at large. It's a public offer, right? Say, IPO, initial public, offer that is given by companies in terms of share subscription can be a general offer. Anyone in the public can actually apply. So general offer is like, I announce a reward. I say, whoever is willing to find my dog, if you do find it, I'll give you a reward. Right? So general offer, a gentleman makes a promise. he makes a proposal and he wants anyone in the public to actually accept the same. Right? For example, in this class, I say anyone in this class who gets the highest marks will get a gold coin. This is a proposal that I'm making to you. So anyone in this class, it could be a group of 100, 200, 2000, anyone who accepts it probably is accepting a general offer. Right? So that's what general offer is. So counter offer is, parties actually sending the offer back and forth. Right? Suppose I make an offer to sell my house to you. I'm the seller, you're the buyer. And I say that I'm willing to sell my house to you for 15 lakhs. You do not accept it. You rather say, I am willing to buy the house at 12 lakhs. Right? See, an offer has to be accepted as it is. We say acceptance is like the mirror image rule. So however the offer is, that is how the acceptance should be. So any kind of conditional acceptance. Now, what is a conditional acceptance? You're not willing to buy it at 15 lakhs. You say 12 lakhs. That's a condition, right? You are willing to buy it, but you want it at 12 lakhs. Now, this 12 lakh has to reach me, right? I'm the offerer, and I would consider this new thing of 12 lakhs to be a counter offer. Now, it's for me to actually then make an acceptance. Right? So counter offers are kind of a conditional acceptance, which are not actually acceptance, which are not accepted as acceptance, and the counter offer is subject to an acceptance. Right? So during modern contracts where there is bargain, where there is negotiation, I think offer and counter offer keep flowing between the parties, and that's how you notice that this is something that one needs to understand, because counter offers are still offers. They don't result in a binding contract. It's not amounts to an acceptance. And unless a counter offer is accepted as it is, contract does not come into existence. So that's why one must understand what a counter offer is. Next is continuing offer. Now, continuous or continuing offer is like a standing offer. You say it could be like this: like a stationery shop owner is willing to supply stationery to a university for the next 1 year. He says item number 1 to item number 10. It could be pencil, rubber, paper. It could be cartridges. It could be anything that is required as stationery in a university. He says for the next 1 year, these are the rates. These are the items at which you can actually come and buy from me. Right? So he is putting that continuous offer. And continuous offers are from long-term contracts, right? It could be in the supply of coal to a thermal plant. You say for the next 1 year, I am willing to supply coal to you. This is where the supply is coming from. So it's continuous in that sense. So it's not one-time transaction. It is a continuous transaction. So this continuous offer is quite common in many of the contracts. And because you want long-term business settlements, you want consistency and uniformity, you want to know that only this party can sell the commodity or the goods, you would expect continuing offer or continuous offers as well. Finally, if you look at the time or kind of offers, there is something called cross offer. Now, cross offer is, friends, it is crisscrossing each other. Right? That's what cross offer is. Say the buyer and the seller at the same time about the same house make a proposal to each other, right? Without knowing that the other is willing and prepared to make the proposal. So these two offers cross each other, right? And cross offers are not contracts, right? One of these offers, which is crossed between the parties, has to be accepted by the other party. So this is just as a kind of a type of offer you would want to think about it. Just to clarify that cross offers are subject to acceptance, and just because they have been made at the same time between the same parties and they're still in the proposal state, please note, it is still an offer, right? And unless the offer is accepted, there is no contract. So offers need an acceptance, and without that, a contract cannot come into existence. So these are some of the jurisprudential part of contract in offer that you should understand. And I think that would be a good way of starting the basis of what a contract is. The second thing that we have to understand is who can make an offer in a contract. Friends, one will have to definitely understand that apart from being a person of sound mind, because please note, a person of sound mind is disqualified from making an offer. He's disqualified from making a contract. The essential condition is person has to be of sound. There are other essentials, we'll come to that in a little while, but please understand, apart from being a person of sound mind to make an offer, you have to have the capacity and authority to make the offer. Now, why is this relevant? Is because, friends, please understand, if you're a natural person and two persons meet physically, the offer can be made and exchanged, and acceptance also can be made. But if you're making the offer as a natural person on your own behalf, there is no problem. I can judge whether you're son mine, whether you're a major, and then probably your offer can be treated as a serious offer. But when it comes to institutions or corporate citizens, the point is who can make such an offer. Right? Say a company, a university, say a partnership firm, be it a cooperative society, be it a trust, be it any of these so-called legal personalities. The issue is from these companies or legal personalities, who has the authority to make the offer. See, generally, say, take the instance of a university. We say it is the vice chancellor of the university who can make the offer because he is the highest authority in the university. But that's not necessarily the case. It could be the registrar who also may have the authority to make an offer on behalf of that kind of a university. So I think, interestingly, when it comes to institutions, it is very important to understand who actually can make this offer, because there has to be delegation of authority. And unless you have the delegation of the authority, the offer is not going to be valid. For example, government. When government makes a contract, on behalf of the government, who has the authority or the capacity to make that kind of an offer, because only then that offer becomes legal and valid in law. Now, an interesting case, to highlight at this point of time is Paul versus Lee. It's a very interesting case if you want to know the facts of this case. What happened in this case was a gentleman applied for a job in a school. Okay, he applied for the job. He was called for the interview. He attended the interview. He did very well in the interview. He came back home. He was expecting a call for confirmation of his job. And later on, a call comes to him saying that you have been selected. Right? Now, out of sheer enthusiasm, what this man does is he resigns from his existing job, saying that, okay, now I've got selected as a headmaster. I'm going to soon join. I've already got a call. And hence, there is no need for the previous job. So he leaves that job. Now, the guy waits for some time, but nothing officially comes in terms of a letter. He's just got a call. And then he lands up at the school and says, look, I've got the offer, but you're not calling me. What's the issue? The school says, no, we haven't officially confirmed your appointment at all, and we have not officially issued an offer letter. But the gentleman says, look, I got a call. And they said, you have been selected. Yeah, but just because you have been selected, does it mean that the letter is given to you? The term selection is a good enough offer, or what is it? And interestingly, the school said, who called you? Did you verify whether the caller had the capacity to actually make the call and give you the offer? So in this case, you will notice that if in a school like this, if a clerk calls up and says you have been selected, and he was not officially authorized to make that call, the call and the offer in the call, if any, cannot be considered as a valid offer at all. And if there is no valid offer, friends, from a person who has the power to make the offer, there cannot be acceptance. Because this is the initiation of the commercial relationship. The initiation of the commercial relationship has to be valid and enforceable. If this does not happen, the acceptance cannot happen. If acceptance does not happen, contract does not happen. So I think the basis of a call can be an offer, there's no doubt. But who has made the call? Did he have the authority to make the call? Did he clearly communicate that there is an offer, or did he merely communicate that there was a selection? And the details of the offer are obviously something that your letter of appointment would state. Right? That could be the basis, and that is how an acceptance can go forward. So this case actually highlights and magnifies the aspect that it's not every person can make an offer. I think one must understand who can make an offer as well. For example, take joint Hindu family system. Friends, in an undivided family, which is called the HUF, the Hindu undivided family, we say the joint family system in India. We know that there is a Karta in the family. He is the head of it. And then there are co-parcelaries of the family as well. Now, you have to understand that everyone is the owner of that property. But who can make an offer on behalf of that property is a very, very critical question. Just because you are a joint owner of the property, do you have the right to make an offer? Say in a partnership form. Just because you're a partner, do you have the right to make an offer? Because remember, in a partnership firm, you may just be the sleeping partner. You may not be the executive partner or the managing partner. And unless you are the executive or the managing partner, and unless the partnership deed has authorized you to represent the partnership, you cannot make an offer on behalf of the partnership. So I think it's very critical at this point of time for us to understand that it's not every person who can make an offer. We must understand who has the capacity, the authority. He or she can make an offer, and that can be then accepted for the contract to come into existence. Right? So joint owners can definitely make an offer, but please know you can make an offer only to the extent of your ownership, not to the entire property. So unless the other person has consented or unless the proposal is joint, the offer is not going to be valid in that extent. Right? So that's important for us to understand as well. Third thing, friends, it is very important for us to understand the distinction between offer and invitation to treat. What is an invitation to treat? Let's understand this. Friends, I'm sure you have gone to a shopping mall. You have gone to a mall in which there is a grocery store, and as soon as you enter the grocery store, there is a cart that is given to you. So this cart is also there online. Now you have the physical cart system as well. So you take this cart and you go into that shopping mall. You are actually shopping. You go here and there. You see a lot of products that have been displayed over there. Now the products that have been displayed in a shop, can we consider that to be enough? Is it possible for us to consider that to be enough? Think about it, right? So they're goods displayed, right? Now what we do is we pick up these goods, right? Now as soon as the goods are picked up, can we say there is acceptance? Because if the goods are displayed and if you pick it up, we must say that an offer and acceptance come into place, and then there is a contract. So if the goods that are displayed are considered as offer, of course they have been offered there for sale. And then if you pick it up, we must consider acceptance. But look at the situation. Friends, the situation is, you may actually go from one line to another line in that shopping mall, and then you may think that I have a better product, so I don't want this, I want this. So you can change your mind. Right? Now, it's not only you who can change this mind. Even when you go to the cashier and you are placing the goods, at the very last minute, you can withdraw certain goods if if you're not happy. The cashier may also reserve the right to make the sale to you. Right? So please understand, in a shopping mall, it is not the mall that is actually making the offer. This is something that you have to understand. They're just inviting you to view what goods are for purchase. You can pick these goods. And to be honest, friends, it is you, the consumer, the purchaser, who is offering to buy. So you place the goods which you want to buy. You put it across, and then it is for the shopping mall owner or the store owner to actually make the final acceptance. He may say, sir, no, I don't want to sell you this because that has been reserved for somebody else, or the stocks are not there. We will not give you this promotional offer. It is subject to conditions of sale. So we will finally decide whether we are going to sell it, we are whether going to bill it, and then we will give it to you as owners of the same. Right? So an invitation to treat is very, very important for us to understand, friends, because it is pre-offer. Right? It's a position where people have been called about to view, to see, then decide whether you want to purchase. So you have the final right to purchase. You will probably make the final call to either place or make the offer or not to make the offer. Right? Now let's look at what can advertisements do. Generally, friends, we see a lot of advertisements. It could be online advertisement, it could be paper advertisement, it could be advertisement on the radio, social media, so on and so forth. So today, advertisement is probably the method in which probably marketing is done. Now, when advertisements say 50%, come and buy, we'll give you discounts and promotional schemes. You can go to Switzerland, so on and so forth. There are a lot of these advertisements that come from time to time, isn't it? Now, what are advertisements in contract? Okay? How do we treat advertisements? Now, suppose you come across an advertisement for an auction, right? Say it's an auction of plots that the government or say the development authority is going to take. And a date is fixed, a time is fixed for the auction to take place. So you see the advertisement, you want to buy it, and you go to that place and you are right on time over that, but the auction is called off. Can you sue the government for the promise that is made in the advertisement to organize and conduct the auction? Friends, the difficulty of advertisement is, advertisement are not serious in nature. You can't consider them to be, aren't they making a general offer? Because see, the purpose of advertisement is actually to provide you information, right? It's not something that is very clear. Okay, this is like an offer, this is what we'll do. It's not, advertisements don't have that specificity of promises, right? So generally we say advertisements are just an invitation to an offer. You are invited to make an offer. So you have to go to the auction. Suppose the auction takes place, you bid. And as the person who is bidding, please note, you are making an offer. It is subject to an acceptance of the auctioneer, which is the government. And if it is accepted, then a contract comes into place. So bidders have to make an offer, and calling you to the bid is generally an invitation to make that offer. So anything that is pre-offer, friends, should be treated as either invitation to treat, that is visual treat to the eyes, come see the goods, see the display, see the variety, choose whatever you want, compare it, spend time, and then buy. Or you are invited to make an offer, so please come to this place where the auction will happen. If it happens, you decide to make an offer. You may decide not to make an offer. You may decide not to buy. That's also fine. Maybe come see the plot, see the place, and then make an offer. That's also fine. Right? So you're invited to make an offer. So this is where the judges in contract law felt that every kind of initiation, every kind of proposal cannot be treated as an offer. There are certain proposals that have to be treated as pre-offer. There are certain proposals that have to be treated as just merely information. If the proposal contains every other aspect that we think are important, for example, did the proposal have all the specific obligations that are there? Did it have specific promises? Then the proposal can be treated as an offer. Otherwise, the proposal has to be treated as mere information. Right? So the content of the offer, the specificity that is there in the offer, all will be important to actually determine whether it is offer as per contract law that can be accepted as well. So we have to also notice that we have two parties in a contract, right? One who offerer, one who offeree. So offerer and offeree make a contract, and this is where contract law comes into existence when two parties exchange the promises between themselves. So as I told you, this is a law of promises. You have to exchange those promises, right? And it should be something that should display the intent of the party. Without intent, contract cannot come into existence. So intention plays a very critical role. Because see, if the offer is not intended to be in similar fashion, then it fails to be an offer. Second, there must be some kind of definiteness. Right? It must be very clear of what it is being said. And the communication of the offer is very, very clear. So unless the offer, say, suppose it's only in my mind and I don't say it, it cannot be considered. So you ought to communicate it in some form, electronically or physically or orally as well. So the communication must reach the offerer, from the offerer to the offeree. And once the communication is complete, then, to that extent, an offer can come into enforcement. Friends, the next issue for our consideration is trying to understand, can advertisements ever be an offer? We know that advertisements are only for general information, but can they ever be an offer? Now, you notice that advertisements are of two kinds. One in which you get real offers. What that real offer means, he says, for if you buy 12 kgs, I give you 1 kg free. Then they say, look, there is a specific promise that suppose the first 10 customers who come to my shop will get 10% discount. there are advertisements from institutes which say 100% job placement guarantee, right? It's job guarantee or job placement guarantee, right? 100%. So every student will get jobs. Right? These are some very interesting advertisements that are generally being made from time to time. So one should probably understand that. Now, the most famous case on this is called the Lil versus Carbolic Smoke Ball Company case. This is the most popular case. Mrs. Carly, she filed a case against a company called Carbolic Smoke Ball Company. It was a pharmacy company producing pharmaceutical drugs. They're a very interesting case. Right? Now, what happened in this case was an advertisement, something very, very similar to the screen that you see, was given by this company. It was producing what is known as a smoke ball. It was kind of a drug. And during those days, influenza was unfortunately quite rampant. We see that kind of influenza coming from time to time, H1N1 influenza, so on and so forth, swine flu, and so many other kind of pandemic diseases are coming from time to time. And companies do come up with some kind of drug to tackle this. But this was a new drug in the market in UK, and hence the company was quite overconfident about its own drug. So they came up with an advertisement and they said, look, please buy our product and please consume it, say, 2 times a day for 2 weeks. And if you do that, you will never ever contract influenza. Right? This is a drug against influenza. But the company did not stop it at that. They said, in case even after you take our drug, you get influenza, you will be given a reward of £100. This was quite in the late 18th kind of century and 19th century. £100, quite a huge amount. They said, we will give you as a reward. Now again, the company did not stop over there. They went a little bit forward and they said, look, we will give you this £100, and as our assurance of the reward that we want to give, what we have done is we have deposited £1,000 in the bank. This is an addition. To be honest, for me, in modern day contract, if I have to equate this £1,000 in the bank that is kept to give this reward, it can amount to something called an escrow kind of bank account. Right? Escrow is again a modern type of contract, so one will probably read about it, how escrow now assists contract. So this was the advertisement that was posted, and Mrs. Carlyle saw this advertisement. She went to a pharmacy, she bought this drug, she consumed it as per the prescription, and despite she having taken this kind of a drug, she got influenza. So what did she do? Now, any other person would probably not litigate or take it to the court, but this lady decided that she wanted to hold the company responsible for the advertisement and the promise made in the advertisement, and so she claimed her £100 reward. What did the company do? The company went to the court and said, look, this is just an advertisement, this was just for information. Right? How can advertisements be offered? Because we have given this advertisement in a newspaper and I don't know how many people have read, how many people have consumed, no one has informed me. So I precisely don't have the numbers. To whom do I then give the reward to? But then the judge asked the company, why did you even announce a reward in the first place? See, announcing a reward is a specific kind of promise. For example, I announce a reward of say £100 to any person who finds a dog that is missing, my dog that is missing. And someone finds the dog and gets it back to me. Shouldn't I be obligated to give that reward of £100? Right? Isn't the case very similar here as well? So if people make these kinds of advertisements or give these kinds of information, they will just get away. Shouldn't there be some binding nature and quality to what has been said in this kind of advertisement? Today we speak about misrepresentation in advertisements, right? Misleading advertisements, because this is the way in which a commercial transaction starts. Advertisement and the information in the advertisement starts to make an offer. So if my basis of making an offer is the advertisement, anything that is misrepresented or misleading in the advertisement, my offer will also be misled to that extent. So my assumption could be misled as well. So shouldn't there be some legal obligation to pre-contractual documents or to pre-offers? Right? That's one part of the story. But look at this advertisement. Friends, it's not a mere advertisement of information. It's a specific promise to give a reward. It's a specific promise to pay, right? Now, government may come up with these kinds of advertisement. For example, the police says, we'll give you 1 lakh if you give information about a criminal, right? So I give that information about a criminal. Shouldn't I be entitled to that 1 lakh rupees? Right? So many of these advertisements, friends, are not merely in the nature of information. They have something different. Right? So it's important to categorize this advertisement very, very clearly. Point one. Now, the company in this case came up with another difference. They said, look, Mrs. Carlyle, though she consumed the smoke ball, did she buy it from us? Did she come and take it from the company? No, she went to the pharmacy and did it. So we don't know whether she actually took it or not. Right? But the court said, look, the pharmacy that is selling this medicine is like your agent. You can't expect everyone to come to the company and buy it. You have given it to the pharmacy, wholesaler, and retailer, and the retailer then gives to the consumer. The privilege of contract should be there. And obviously, if Mrs. Carlyle can produce the evidence that she has taken this from anyone in the agency line, she should be entitled to that. So it's not necessarily just you come to the company. Then the company said, look, we should have monitored her consumption. But that you did not say in the advertisement. She should have informed us before consuming. That you did not say in the advertisement. So, to a larger extent, the company also went up to say that this is like a wagering contract because, it's so much of gambling. We don't know whom to give, who gets influenza. Should we end up giving this reward to everyone who gets influenza? We just gave it to, incentivize people to buy. Why should we be forced? Why should it be a legal obligation? But the court simply said like this. Once you have announced a reward, that is an offer. If anybody who fulfills the condition in this advertisement, that fulfillment of condition is an acceptance. So you have acceptance by conduct. It's not necessarily that acceptance always must be communicated. If it's communicated, well and good. But if it's fulfilling what is there in the offer, right, then that should be good enough. For example, I announce a reward for anyone who runs 10 kilometers in 10 minutes. So if you complete that 10 kilometers in 10 minutes, by just completing the condition in the offer, that is what we say acceptance by conduct. I think you should be entitled to the reward that I announced. So the court in the Carbolic Smoke Ball Company case very clearly said that this is not an ordinary advertisement in the nature of information. This cannot be considered as an invitation to an offer. This is clearly an offer. It's a binding obligation on the company to give this £100 reward. Okay. So this is where probably, friends, you will notice that sometimes we may have to consider advertisements as offer as well, depending upon the content it actually provides for. Now, you see a lot of advertisements on tendering contracts that are given by the government. Government usually makes an announcement in a newspaper or online, and they say this is the tender, right? We want people to participate. Now, most of these tenders are, friends, please note, they do not have a specific promise. They are just calling bidders to participate in the bid. They're saying, look, we have general conditions. This is what you should fulfill. There's a tender document. So, government is very clear. What we publish as an advertisement is only a pre-offer. It's an invitation, right? So you cannot consider this to be like Carbolic Smoke Ball Company case. So I think advertisements can be offers if there is a specific obligation to pay. Otherwise, if you don't make any specific obligation, if you don't make any specific promise, you don't create an obligation for yourself. Because look, in the Carbolic Smoke Ball Company case, the company creates an obligation for itself. We will pay £100 reward. So if you have created an obligation specific that can be identified, that can be certain, then the court will impose that obligation on you. And that's why I started off saying, friends, that the contract law is nothing but a law of obligation, right? If you are undertaking that obligation on your own self towards someone else, the court is just going to make you fulfill those obligations. If a guaranteed job, no one has asked you to do it, but if you're guaranteed job, you better fulfill those obligations as well. So I think any of these kinds of attempts to come up with some kind of a marketing gimmicks or strategy in which specific obligations are undertaken, please note some of these advertisements should be treated as offer, and it would create a legal binding obligation, and it will start a chain of legal implications for which companies will be bound by. And if they fail to give this, it would amount to a breach of contract. moving forward in understanding offer as the first essential uh, aspect of making a agreement or contract, one will notice that the definition of a proposal or an offer is there under Section 2A of the Indian Contract Act 1872. It states something like this. It states that when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain the assent of the other person to such act or abstinence is said to have made a proposal. Now, the definition that is there in Section 2E of the Indian Contract Act also is critical, because it says every promise and every set of promises forming consideration for each other is an agreement. So there should be promises and set of promises to actually make an agreement. Interestingly, friends, offer, when we look at the concept, we say it must be made with an intention. Intention for what? Intention to create something of a serious relationship or a commercial relationship. As I told you earlier, friends, for an offer to be making a contract binding, that offer should be made by a person who is sound mind. Maybe it should be made by a person who is an adult or a major above 18 years. Further, it is also about in what context and in what intention did he make that particular offer. Friends, let's take some instances about our intention. Now, please note, we kind of make a distinction between social contract and legal contract. Right? A legal contract is what we are focusing today on because it's enforceable at law, but social contracts are not, social agreements are not. The interesting case that can, kind of magnify this position is called the Balfour versus Balfour case. Balfour, this is Mr. Balfour versus Mrs. Balfour. Right? That's the case about. So Mrs. Balfour actually filed this case because she wanted her husband to continue to fulfill his promise. Now, husband and wife, father and son, daughter and mother, all of these continue to make a lot of promises between themselves. Right? There are other cases also which are very similar to this, which create the interesting facet that look, we cannot say that contract law is a law for all kinds of promises. Right? So rather, there is an interesting statement. It says that contract law is not the whole law on promises. Yeah, that's right. So it's not the whole law on promises. Promises can be covered under other laws as well if required, or promises can be generally in the social context of the law. So when a husband makes a promise to a wife, now what happened in Balfour was the husband was working in Sri Lanka, Ceylon. Earlier it was called as Ceylon in 1919 at least, and the husband and wife came to England for their vacation. And the husband had to go back because his holidays were getting over. So he had to go back to Ceylon and commence his work. But his wife decided to continue staying in England. Now, because she had to stay in England, the husband said, look, I'll give you £30 maintenance every month, right? Till the time you stay in England so that you can meet your expenses in England. The husband returns to Ceylon in Sri Lanka. And, after a couple of months, the wife decides not to come back, not to join her husband. So the husband stops paying this £30 per month. To which the wife sues the husband, saying that he has promised me £30 and he should continue to pay me in all circumstances. Right? And the couple did separate, obviously, because of the litigation and the lack of continuation of the promise. So the wife said, no, I will no longer stay with the person who is not or is not committed to his promises. The fact is that when the matter came to the court, because Mr. Balfour claimed this £30 maintenance as a promise, the judges in this case had to decide whether the promise that was made to the husband was made with an intention to create a legal obligation. Was the promise a contractual promise? Because there are promises that are floating around the society in so many circumstances. A club may make a promise to give you membership. Right? There could be a promise to, join an, illegal association. You can have several promises that are made in society. Can all the promises be contractual? Can it all be covered under contractual promise? The answer is no, you cannot be. Right? So in Balfour versus Balfour, it was decided that social promises that are made within a household between people in existing relationship, it could be mother daughter, it could be father son. All these promises are not going to be contractual promises because they're not made with an intention to create a binding legal obligation. So if there is intention, that intention will be the test to determine whether the promise is enforceable at the law or not. Right? So these are quite interesting developments in contract because they are all going to the fact that, look, when the husband made this promise, proposal or offer, did he think that this is going to be a contract and it is going to result in a legal relationship? Tomorrow it will be sued under breach of contract. Or was it made in the social context because I promise in the house and we promise between friends? There are so many promises that are exchanged. So how do you read the mind and the intention of the person? Right? So that becomes a very important and a critical factor in contracts. And here is where you should understand that we talk about, say, an MOU, a memorandum of understanding, in commercial contracts. Friends, please note, even in the commercial contract, you can agree not to create a contract. So an MOU can either be a binding agreement or a non-binding memorandum of understanding as well. So it's not necessarily that everything that you agree is to be a contract. There could be just a commercial understanding which is non-binding in character and nature. So it's not necessarily going to be treated as contract. Right? So this becomes a very critical test of contract. And there is another case called Jones versus Padwatan. It's a 1969 case. It's an interesting case about a mother promising a daughter to take care of her studies. If she goes to England, and the mother continued actually. She was a good mother. She said to the daughter, "Please continue your studies. You leave your job, do further studies, finish your graduation." And for a couple of years, the mother supported the daughter, but later on, the daughter did not show any seriousness of completing her studies, so the mother stopped paying the daughter. Now, the ungrateful daughter sues the mother and says, "No, that was a promise that I can enforce in a court of law." Now, the court here clearly held that this is a legal, this is not a legal binding obligation of a mother to maintain her daughter. See, under the law of maintenance, dependents can claim maintenance. That's a separate obligation under a special statute. Say an unmarried daughter can claim maintenance from the parents. Elderly persons can claim maintenance from the parents. That's a separate legal obligation. It's not a contractual. It's a statutory obligation. But in this case, when the mother makes a promise to the daughter, that lacked that kind of intention that is required to create a legal relationship. It was a social promise, and social promises are not contractual promises. They can never be inferred to be one. And that's how the intention theory becomes a very important theory to test the seriousness of the offer, what the offerer meant, and how the offerer expects this offer to be made enforceable at law. So the intention that is either implicit or explicit is something that the judges will test to actually create contractual relationship. Now you also have to note, friends, the theory on intention in contracts was largely evolved because oral contracts were largely being made during those days. And they were mostly contracts that were made between existing or subsisting relationship, mother, daughter, father, son, husband, wife. Today, usually if two parties do not have a substituting relationship and promises are made, the intention is that the contract and the legal relationship obviously is there unless proved otherwise. Right? So what is the unless proved otherwise? Say in an MOU if it's a non-binding. So that's a proof. Otherwise, an MOU is an MOU. It is also a deed or a document that is to be produced as evidence about the intention that the parties have in that kind of relationship. So I think with this discussion, friends, I think what we have to understand is offer is very, very important. It has substantial aspects to be covered, especially in the fact that you can either make an offer explicit or implicit. But communication of an offer is very, very essential. Intention is also very essential. We can have specific offers, we can have general offer. Advertisements can also be offered, right? Because if they are having a specific obligation, and hence, with this, I think we should now move on to our second aspect of what we call as acceptance. Okay. Now, interesting difference, an offer has to be accepted. So it is communicated to a second party. The second party is the one who actually creates the acceptance out of it. Now, the rules of acceptance are something like this. There is a very, kind of a very, highlighted statement of Anson, a jurist and an author in contract law. He was someone who was in common law. He said that acceptance is like a lighted matchstick to a train of gunpowder, which cannot be recalled back. What it meant was that once acceptance happens, the legal obligation starts, and after that, nothing can be done. Contract is formed. And that's why it's like a train of gunpowder. It blasts a legal obligation, which is then enforceable in the court of law. Remedies are there, rights can be enforced. That is how the statement is highlighted. Right? Acceptance is like a lighted matchstick to a train of gunpowder. The legal obligation commences, rolls out. Right? Before acceptance, what can happen? Can the offer be revoked? Can the offer be called back? So once I make an offer, can I call it back? The answer is yes, you can. Right? Because you intend no longer to continue with that offer, you can always revoke that offer. But once acceptance happens, revocation is not possible. Right? That's what the statement clearly states. Second, acceptance, friends, has to be absolute, unconditional. Right? So if you go to section 7 of the Indian Contract Act, you will notice that section 7 says it should be absolute and unqualified, and it must be expressed in the usual or reasonable manner. Right? Acceptance also must be communicated. You can't keep it in your mind. And that's why it's the mirror image. Like, however is the offer, acceptance should be similar to that. In case you change the offer, if you add anything in that offer, you put an additional condition in the offer, then it's a counter offer. Right? That's the rule that is there. The third rule is you can only accept if you have the knowledge of the offer. Otherwise, you cannot give the acceptance. Right? There is no acceptance unless the knowledge of the offer exists. And this rule was stated in this very famous case called Lalman Shukla versus Gauri Dutt. Friends, what happened in this case was a landlady was quite concerned on one particular day when her nephew in the house was missing. This is usually called the missing nephew case. So the landlady, out of concern, called the maid, domestic servant, and told that please go and find the nephew. Please go and search for him. So the domestic servant went in search of the missing boy, and he obviously went out of the house. After he left the house, the landlady, Gauri Dutt, comes out in the open. During those days, early times, people would come out in the village, yard or the center of the village and make an announcement. So she made an announcement saying anyone who finds my nephew or the missing boy will get 501 rupees as a reward. This was a general offer. Right? Anyone can go and find it, but this is the offer that was offered by the landlady. Naturally, the villagers were quite keen. 501 rupees was pretty big an amount, so they went in search of it, but nobody found. Who found the missing boy? Interestingly, friends, the servant, domestic servant, found the missing boy. He found the missing boy, he got the missing boy home and handed it over to the landlady and returns back home. The landlady gives him off for the day. She says, you have done very well. Now you go. But the landlady does not give that reward to him. Neither did the domestic servant know about that reward. And who was the domestic servant? Lalman Shukla. He has filed the case. He did not know about it, so he did not claim it. So he handed over the boy and came home. Once he came home, he definitely shared the story with his family and his neighbors, saying, look, today what happened, I had just gone to do work at home, but this boy went missing and I had to find him. I found him and I returned it back to him. So the family and neighbors said, oh, then you must be rich today. You must have got that 501 rupees because this is what was the reward that was announced by your landlady. He says, no, she did not give it the reward. So obviously, he must have gone and asked the landlady, and the ungrateful landlady said, no, sorry, you are not entitled to the reward. Because what you did was out of your own duty as a domestic servant. And luckily for all of us, the servant here decided to file a case in a court of law. Right? And that's how the jurisprudence and the principles of contract law have come forward. So Lal Shukla filed a case for the reward. And the matter goes to the court of law. And the issue was, can the domestic servant be entitled to the reward that was announced in the general offer? So, did the general offer include or exclude the domestic servant? What was the intention of the landlady? The landlady says, my intention was to exclude him, except him to everyone else. And if anyone among that would have found, he would have been entitled to the 501 rupees, but not Lal Shukla. But Lal Shukla says, why should I not be included? It's not part of my domestic work. Domestic work is within the domestic. I went outside. I should have got the reward. But the court in this case said, look, when an offer is made, what is the offer? Find the missing boy, you will get 500. This offer should close when the boy is returned back. Okay? It should close when the boy is returned back. Once the boy is returned back, the offer and so-called, if there is any acceptance, is completed. It's completed. The legal obligation has ended. The reward, for the purpose of the reward, has been completed. If Larman Shukla wanted to accept that offer, which is the 501 rupee, he must have known it. He should have come to know it. Knowledge of the offer is relevant. Right? If you have knowledge of the offer, you can make the acceptance. You can find the missing boy, go, hand over the missing boy and claim the reward. He had no knowledge at all. If he had knowledge, wouldn't he have claimed that 501 rupees before handing over the missing boy? I'm sure he would have done it. He said, no, take the boy, give me 501 rupees. But he had no knowledge at all. So unless you have knowledge, where is the acceptance? Now, once every obligation is completed, he comes to know about the offer after he goes out. So, lack of knowledge of an offer will never result in any acceptance. You cannot later on claim that reward if you had not known about it, because the obligation is complete. The boy has been found. So unfortunately, in this case, though equity would have demanded that Larman Shukla should get the reward, in fact, in contract law, because the acceptor, so-called acceptor, wanted to claim the reward, did not have any knowledge of the offer, and the obligations had been complete of handing over the missing boy, the servant was entitled, not entitled to claim that reward. Right? No reward was given to Larman Shukla. So the rule of acceptance is you can only accept if you have knowledge of the reward, especially in a general offer. See, the knowledge of this offer can either be communicated to you indirectly. So someone might have heard that landlady saying 500 rupees. Okay, he would have told you. That's fine. That's knowledge. It's not about communication. See, communication means whoever is in this class must hear my offer. That's what we say communication. Communication is relevant. But if you cannot receive the communication, you must at least have knowledge to make a valid acceptance. Otherwise, your acceptance is not going to be valid in contract law. Now, who can make an acceptance? This is also very important. Acceptance in a specific offer. Now, in specific offer, please note 1-to-1, right? If I make an offer to you, only you can make an acceptance. No one, third party cannot make an acceptance on your behalf. It's not possible. You cannot, assign your rights to, say, someone else and say, let him make the acceptance. Any of the offer is there. It's like this. Suppose I offer a house to you for 50 lakhs. I say, are you willing to buy my house for 50 lakhs? You don't say anything. But you ask C, the third party, you say, look, there is a house on sale for 15 lakhs. You do one thing, you accept it. See, if I have communicated the offer to you specifically, only you can make the acceptance. You cannot assign it to someone else. If that someone else is interested to buy the house, he should make an offer to me. And then my discretion is either to accept it or not to accept it. Right? That's how the rules of acceptance are also critical as the rules of offer as well. Also, friends, please note there is a very interesting issue on whether silence can amount to an acceptance. This is an interesting point. Right? We have said before that silence is like non-communication. Right? See, acceptance is of two kinds. Either you communicate the acceptance explicitly, or I told you acceptance can be by conduct as well. Conduct, there is some kind of action over there. But can silence itself be an acceptance? This is something that is very critical over here. Now, we have seen in the past that there are communications that are being made. For example, in a horse case, what had happened was there was a communication saying, look, I am interested to purchase your horse for say $1,000 or $100. Right? If I do not hear from you in the next 3 days, I will consider the horse to be mine. People can actually use such communication. Right? I want to buy your horse for £100. If I don't hear from you in the next 3 days, I will assume the horse to be mine. Now, you don't say anything about it. Can I consider the horse to be mine? Whether your silence amounts to an acceptance. So, can I force you to say something within those 3 days? Right? Think about this very clearly. Second, you know that at one point of time, credit card companies used to send credit cards unsolicited. Right? Unsolicited means without you applying for it, they would send these credit cards. Unsolicited marketing is actually a huge problem. Now, let's assume that you open the postal cover, you see the credit card, your name is there, date of birth, everything is there, and you keep it in your drawer. By opening the packet and keeping the credit card in your drawer, can that amount to an acceptance of the contract between you and the credit card company? Right? Now, you will notice, friends, it would be pretty dangerous for law to say silence can be acceptance. It is very dangerous. Right? We should never permit any such system because communication is very, very important. Now, for example, in the credit card company, how can you prove acceptance by conduct? Suppose I keep the credit card in my drawer, that is definitely not acceptance because it is silent. But if I decide to use the credit card, by conduct I have accepted thereof. The use of it is by conduct. So, communication can be dispensed off with in such circumstances. Another interesting case is this LIC versus Abasi Reddy on this particular point. What happened in this case was a gentleman wanted to take life insurance. So he called a broker and he said, give me life insurance. The broker filled the form. He took the first premium check. Then he went to the LIC. He deposited the check and the form. And LIC was preparing the form. Right? You have to read everything, the documents, the supporting. And LIC had processed this application form and they were kind of about to issue him the insurance policy. Right? This was within the organization. In the meantime, unfortunately, the policy proposer died. He lost his life. And his wife now wanted a claim of the benefit from the life insurance policy. So she filed a case. Now LIC said there is no contract that has been made. Right? We have not communicated our acceptance. But the lady said, look, what is communication of acceptance? Look, I have filled the form. I have given the first premium check. You already taken it and deposited in your organization. That is acceptance. No, LIC said that is not acceptance. Deposition is not an acceptance. We have to issue the policy certificate. And please note, issuing of the policy certificate within the organization is not sufficient. We have to post it. It should reach you. Communication means communication to the offerer. So from our side, no such communication has been sent. We might have processed the file. That is internal, but have we communicated to you? Okay. Then the lady said, look, can we assume that encashment of the first premium can be acceptance by conduct? Maybe yes. Right? Though you are not communicated. If you have actually by conduct encashed the first premium, it means that there is a level of acceptance. But you will notice that today insurance companies also have a condition which says that your policy will only commence after 365 days or 1 year after the contract of insurance has been made. This is like a buffer time, because in such cases, in short time, if people die, then the whole purpose of insurance companies get defeated. So any such assurance of insurance starts only after 1 year after the policy coming into force. Are conditions that have been imposed after learning from such cases. So the court in this case said, though there is an internal process in which the policy was approved, because there was no communication to the policyholder, the Life Insurance Corporation owes no contractual obligation to cover the life of the policy. So communication is critical, and without communication, I don't think a contract will come into existence. So communication of the offer and communication of the acceptance creates a contract as well. Okay. So if you look at the UK Unsolicited Goods Act of 1971, sometimes communication can be dispensed of, but there has to be by conduct, like in the credit card company case as well. For example, we say sometimes acceptance implied. Right? What is implied acceptance? Of course, you have sold it to the pharmacy. That means you have said this is how acceptance takes place. Right? Anyone who buys, there is an acceptance that we will pay the reward. Right? So these are certain rules of acceptance that can be brought about to actually say offer and acceptance creates a contract which is a binding relationship. Right? These are two important principles that generally we take into consideration as well.